Hello friends, in the YouTube channel Advocate Amit Kumar Gupta. Today I am going to discuss the case of HARSHIT Foundation versus Commissioner of Income Tax. This case has been reported in 447 ITR at page number 372. The matter has been decided by the Honorable Supreme Court and the date of the judgment is April 22, 2022. Friends, we have seen that whenever some timelines are given into the act where the assessing authorities have to act, they are very lazy to react, and as per my experience, timeliness doesn't mean anything for the income tax authorities. They are just for the assessee. For example, when we file section 154 application, when we file lower TDS certificate applications, when we file section 12A registration application, and apart from this, when the question of issuing the notices under section 148 comes, the department crosses all its limits in delaying the issuing of the notices. We have seen, it is our experience, that the notices are issued at the fag end, that is 30th or 31st March. And sometimes the department loses a lot of revenue due to the dispute of the issue of notices. In spite of the various notices which have been quashed, the department does not learn a lesson that they have to do their work in time. But sometimes the assessee gets the benefit also out of that. But in most of the cases, the assessee has to face a lot of litigation because of that. In the present case, the assessee filed registration under section 12A. The application was filed. Section 12AA subsection 2 says that the Commissioner of Income Tax has to accept or reject this application within 6 months. The question arises that if the Commissioner does not accept or reject the application within this period of 6 months, what will be the fate of that application? The assessee was arguing that my application was not considered, whether neither it was rejected nor it was accepted. So the interpretation should be drawn that it has been accepted. The matter was decided against the assessee by the High Court, so the assessee was before the Supreme Court, and the Supreme Court said that in the absence of specific provision that in case the application is not disposed of within the period of 6 months, it will be deemed as accepted. It cannot be said that the application will be accepted in case of non-disposal of the application within 6 months. With due respect to the decision of the Supreme Court, if this is not the law, then what is the meaning of giving the period of 6 months into the statute? It is not serving any purpose. They are delaying the matters like nothing. Or if just when the period of 5 months passes, they issue the notice, the assessee has to rush for submitting the papers, and they make the order in a very clumsy manner, in a very hurried manner, and the principle of natural justice is always kept under the carpets, and the applications are disposed of in a very mechanical manner. But the law laid down by the Supreme Court, Honorable Supreme Court in this case, is that if the application is not disposed of, neither it is rejected nor it is accepted, then it will not be deemed as accepted. The limited point which was adjudicated in this matter was this. But my humble appeal to the government is that whenever the timelines are there should be some responsibility of the authorities, and they should be followed very strictly. There should be a system that whenever the assessee writes a mail to the department, there should be proper response from the department. But except in very few cases, I have seen that whenever we write mail to the income tax officer or the higher authorities, we do not get the response from them. So, as far as the timelines are concerned, where the department has to react to them, to the applications of the assessee, they are very lazy in that. And now after this decision, they will be more motivated to delay the applications of the assessee. At the end of this video, once again I am repeating the name of the case. The name of the case is HARSHIT Foundation versus Commissioner of Income Tax, and this case has been reported in 447 ITR at page number 372. Thank you, friends.